Good evening. This is John Milburn for Laws 11062. This is Contract B. We're into week 10, and this is term 3, 2019. Tonight we're dealing with the topic of remedies, which is a continuation of what we discussed last week. But more specifically tonight, we're talking about restitution, equity, and most importantly, Section 18 ACL remedies. A word of warning though, when it comes to dealing with the issue of remedies, there is a temptation to become very litigious in the way you think. And whilst I don't really expect you to go into a lot of alternatives in an exam situation where I'm really focusing on the specific remedies, from a practical and, if you like, holistic approach, just remember the ethics associated with seeking any remedy. So as you've probably picked up, I'm very keen on ensuring that you're consistently aware of ethical obligations, particularly in practice. And when it comes to providing advice on remedies, one of the very important aspects is that commercial litigation does not always need a courtroom-based outcome. And there is a quote from a case called McLaughlin and Dungarran Manley, Pty Ltd. This is 2011 New South Wales Supreme Court 717. And at 30, the court said, it needs to be emphasised that the efficient conduct of commercial litigation, indeed all litigation, can only be assisted by restraint, moderation, sensible cooperation and sound judgment. Indeed, the due administration of justice demands it. That is part of the wider duty to the court. So I don't expect you to quote that case as part of your assessment, but just keep that principle in mind, that when we're talking about remedies, we're not necessarily talking about a win at all costs approach. And being ethical is one of your essential tools in practice. And indeed, in the study of law, it's also very important. Threshold learning outcomes for a law degree address the question of ethics in a detailed manner. And threshold learning outcome number 2 deals with ethics and professional responsibility, and it requires you to demonstrate an understanding of ethical decision making and an ability to respond to ethical problems as they arise by developing an understanding of how to go about exercising your professional responsibility and professional judgment. So it requires you to reflect on your responsibilities as a lawyer to promote justice, to serve the community. So a good resource, I'm sure you're all aware of it, but if not, please acquaint yourself, is the Queensland Law Society Ethics Centre, which is a remarkably detailed, well-researched and highly authoritative site led by the team there, led by Stafford Shepherd, do a great job for Queensland solicitors. And remember, of course, the Australian Solicitors Conduct Rules and also the Barristers Rules. I would recommend that you also have a look at the Legal Services Commissioner website, which has also some very good information. So Parker and Evans are academics, and dealing with the issue of ethics of care, make the comment that whenever you're providing advice, you need to take a holistic approach, whatever you deem that to be, so that when you're involved in a dialogue with your client, it's a dialogue that is likely to be involving real participation rather than a matter of simple exchange of instructions and advice. And you're always required to look for non-adversarial ways of resolving dispute. So when it comes to the Australian Solicitors Conduct Rules, with all of that in mind, within the context of remedies, think about particularly rules 3, 4, 5 and 6 of the Australian Solicitors Conduct Rules, being your duty to the court as being and the administration of justice as paramount and prevails over other duties, then of course you have duties to the client, to the opponents as well. So when it comes to advocacy and litigation, have a look at rules 7E to 29 inclusive. And I think I mentioned these last week as well. The barristers' rules, the barristers' rule, which is from the Bar Association of Queensland website. Have a look at some of the rules that relate to being a barrister. Now, just coming back to the Queensland Law Society website, if you want to get a better idea of how this might work in practice, there's an excellent interactive part of the program that's called an ethical deliberative model. And if you look at that, it will give you information about the deliberative model, see how it works in practice, and it's a very good practical tool, as are some of the Queensland Law Society guidance statements. The only other thing that I'll mention on ethics is the issue of capacity, in that when you're obtaining instructions from your client, you need to be satisfied that your client is capable of providing those instructions. So just a good thing to have up your sleeve for general knowledge, and sometimes to introduce as maybe an assumption or to question something that may arise in a legal question, is the Guardianship and Administration Act 2000. That's a Queensland legislation. Have a look at Schedule 4 and you'll see the definition of capacity. So capacity for a person for a matter means the person is capable of understanding the nature and effect of decisions and freely and voluntarily making decisions about matters and communicating those decisions in some way. And if there are concerns about capacity, the appropriate forum, at least in Queensland, for a determination as to whether someone does or does not have capacity is QCAT, the Queensland Civil and Administrative Tribunal. So these are just some of the background things from an ethical perspective that you want to consider when you're considering the question of remedies. Now, any questions about ethics, capacity, those preliminary comments that I've made? All good? I'm not saying all of those things as an exam hint. You won't be examined on those, but I do want you to have them in mind, and you can make some brief reference to those sorts of things from time to time. But what we're really here to talk about tonight are remedies in relation to damages, equitable remedies, restitution, the Australian consumer law, and things of that nature. So now Samara has a question about the exam. Will I be putting up past papers? Now we're into week 10, so I will provide some further guidance. I'm not sure that I have access to too many past papers, and just even if I did, they may not be entirely relevant because in the past the examination was 3 hours, whereas your examination is 2 hours. But it's a good question, Samara. I will provide some guidance during this week, and I will look to see, look to find something that might assist you in that regard. Has anyone come across any past papers?
Yeah,
Tanya?
I think there was 3 actually linked to the unit profile.
Oh, there were? Okay.
Yeah.
All right, good. And that's in Moodle, of course. All right, thank you. So hopefully, Samara, if you still have trouble finding those, please ask through Q&A and hopefully we can identify more clearly where they are. Thank you, Tanya, for that, and thank you for the question, Samara. Any other questions, comments? All good? All right, so equitable remedies. There's a few maxims always useful to have in mind. One is that equity follows the law. So essentially, an equitable remedy is available if the court's satisfied that common law remedy damages is inadequate or there's no satisfactory remedy by statute, such as the Australian consumer law. Equitable remedies are discretionary. And of course, that's the nature of equity is that it involves a good deal of discretion. So judges have a discretion as to whether to grant equitable remedies, such as specific performance or injunctions. And the conduct of the party that comes to the court asking for the remedy is always relevant as well. So there's a maximum. One who comes into equity must come with clean hands, meaning that your conduct will be scrutinised by a court as the applicant, just as much as the respondent's or defendant's conduct will be scrutinised by a court. In other words, the integrity of the court, the process, is always going to be foremost in the judge's mind. Therefore, the court will be reluctant to provide some sort of approval, tacit or otherwise, to bad conduct, for want of a better term. So as a matter of public policy, that conduct which is unmeritorious will be penalised by a court, and the court will ask whether the bad conduct was intentional or otherwise as part of its decision-making process. Now, I've just seen a note that my internet connection is unstable. I'm sorry. If it continues, I'll cut out the audio, the video, and if there are problems, please let me know as we proceed. What I would ask you to do, if I haven't asked you to consider this already, is have a look at the Civil Proceedings Act 2011, Queensland legislation. Have a look at Section 8, which deals with equitable damages, and see if you can work through that section and understand it. Now, it's a really short section, and this is what it says. If a court has jurisdiction to hear an application for an injunction or specific performance, the court may award damages as well as or instead of an injunction or specific performance. So to understand that section, you need to understand what we mean by jurisdiction. Jurisdiction, does the court have the legal right to hear this matter? So if the court does have the legal right to hear an application for an injunction or specific performance, it can award equitable damages instead of or as well as injunctions or specific performance. So do we know what an injunction is? Do we know that an injunction is usually prohibitory, but sometimes mandatory? In English, sometimes the court order is used to stop someone from doing something, which is most of the time, or alternatively, it's to force someone to do something, which is to compel or to mandate, and that's the mandatory injunction. Also, an equitable order is specific performance. Now, it seems like it's a mandatory injunction, but there is a difference between a mandatory injunction and specific performance. And specific performance is generally an order granted by a court to compel performance of, say, a contractual obligation. So specific performance is equitable relief compelling the completion of the contract in question, as opposed to a mandatory injunction, which might be to, you know, to do something that's unrelated to a contract. A good example for you to work through, has anyone bought or sold real estate? Have you had that joy? Or maybe you're involved in the industry to some degree, but you might be aware that in Queensland, there is the REIQ contract, which is by far the most commonly used contract. It's not the only one, but it's the most commonly used contract for the purchase and sale of houses and residential land, and separate contracts for commercial properties and businesses. But if you're able to find a copy of Houses and Land Contract REIQ, it was useful to work through some of the terminology because it provides for a few things that we're talking about in this week's content. For example, the contract provides that the seller or the buyer may either affirm the contract or terminate the contract in certain circumstances. So you need to understand what the terminology means. What does it mean to affirm? What does it mean to terminate? And have that written down in some sort of ready reckoner as a definition so you're clear on the language. The REIQ contract also provides for specific performance or forfeiture of the deposit, the ability to resell, and damages. So a number of options are available in that context as well. Now, so parties then can rely on the Australian consumer law for damages for misrepresentation or misleading conduct. So therefore, and just to answering Gary's question, yes, sections 236 and 237 of the ACL do apply. The Section 8 of the CPA can work in conjunction with the ACL. I hope that answers your question. So I mentioned that you need to be clear as best you can on terminology. So do we know what we mean by terminating a contract? There's only a small class, so I won't pick on people. Do we know what we mean by termination and when that applies? Do we know what we mean by rescission and when that applies? And Samara says, yes, termination is to end. Very good. So if a party breaches a condition, then the aggrieved party must make an election, either to terminate the contract or to affirm the contract. As Samara would say, to end the contract in the case of termination, or to affirm, to agree to proceed with it in the case of an affirmation. And Samara says rescission is to put them back to where it was before the event, which is really in the context of vitiating factors. So if a party in a contract finds the other side has breached, then you need to you've got this election. Do I terminate? Do I affirm? And if a solicitor affirms or terminates a contract for their client, the election by the solicitor is binding on the client, even if the client had no specific knowledge of the facts giving rise to the election. So it's really important, and I'll highlight one case in particular where that occurred, and it's really important then that solicitors understand that they speak for the client and what they say is binding on the client. So that's a practical aspect. Now, failing to elect to terminate a contract when entitled to do so will not necessarily mean that it's treated as being an affirmation. Conduct is also important. The time that it takes is also important. But if you purport to terminate a contract down the track, you may encounter difficulties because your opponent may say that your failure to act or the conduct that you undertook between the event and the termination is a deemed affirmation of the contract. Oh, I hope that makes sense. In other words, sometimes these things aren't black and white. They're not clear cut, so to speak. Now, am I talking in a language that you don't understand, or are you able to follow me so far? All good? All right, we'll keep going. So in the RAQ contract, I mentioned that a party may be entitled to specific performance or damages or both. And if we think about the Civil Proceedings Act, it says you can have both specific performance and damages as an appropriate remedy in some circumstances. Now, I mentioned the distinction between termination and rescission. Just remember that rescission applies for things like misrepresentation, mistake, all those vitiating factors that we did in the first few weeks. Termination is different. It arises in other circumstances where there's a breach of a contract. But it's not every breach, is it, that gives a party a right to terminate the contract. Let's take a ludicrous example. If someone had committed to purchase 1,000 units of something, widgets, as we say, and the seller was able to provide 999, that's probably not going to be sufficient failure to comply to enable the buyer to terminate the contract, at least in full. So there's got to be some grading of the extent of the breach, isn't it? Samara's on the right track. If it's a breach of a warranty, the aggrieved party may be entitled to damages, but may not be entitled to terminate. Thank you for that contribution. So the type of breach is important. It's fundamentally important. If we're talking about a breach of an essential term, that probably will give the right to terminate. If we're talking about a serious breach of an intermediate term, that will probably give the right to terminate. But if we're talking about a breach of a warranty, we're really only restricted to damages. So when we're talking about remedies in the context of a breach of contract, we need to understand the different types of conditions or clauses in a contract and the categories, and try to, in an exam context, you need to make a call, don't you? You need to say, in my view, this is an essential term, it's an intermediate term, it's a warranty, whatever the case may be. But as Samara said correctly, termination results in the parties being discharged, but the rights and obligations vested before that time do not disappear. It's not like rescission for vitiating factors. Now, a good case to quote as authority for that proposition is McDonald against Denny's Lascelles. It's 1933, 48 CLR 457. McDonald against Denny's Lascelles. All right, so where a contract is rescinded, where there's a rescission, the contract's dissolved, parties return to their original position, it's as though the contract never existed. Terminations available to a buyer, or sorry, to a party where there is a substantial defect or a material misrepresentation, say in the context of land contracts. Now, when we talk about termination for breach, we are talking about the categories. So is it an essential term? Is it an intermediate term? Is it a warranty? But we're also talking about the issue of repudiation. And is it sufficient? Is the breach sufficient? So in general terms, a repudiation of a contract occurs where one of the parties renounces their liability under the contract and essentially shows an intent no longer to be bound by the contract or to fulfill the contract in any substantial way, or only in a way that's substantially inconsistent with their obligations and not in any other way. So repudiation is where a party renounces their obligations and says, essentially, either by statement or by conduct, I'm not going to be bound by the contract. I'm not going to fulfill the obligations in the contract, or I'll fulfill part of the contract, but in a way that's inconsistent substantially with my obligations. Does that all make sense? All right. Can anyone give me a case that's good authority for that general proposition as to what is repudiation? What's a good case to quote in an exam? I'll accept a couple here, but there's one that we see in building disputes in the tribunal. I see this case a lot. All right, write this one down if you haven't already got it. Severable, Severll, against Builders Licensing Board. Severable, Severell, against Builders Licensing Board, 1982 149 CLR 620. 82 149 CLR 620. So that's general authority for the proposition as to what amounts to a repudiation. So as we've identified, essential terms are different to warranties. A non-essential term might still be very important, which then brings in this grey area, and it may give rise for a party to terminate the contract at common law. A leading case is, and I've mentioned this previously, Kumpatu, KOO MPAHTOO, Local Aboriginal Land Council against Sandpine, SANPINE, Pty Ltd, SANPINE, and the citation is 2007, and it's CLR 115. So to allow termination on that basis, the court must be satisfied that this is an obligation of basic importance to have that degree of essentiality. So repudiation goes beyond breaches of essential terms and serious breaches of non-essential terms. It may be an anticipatory breach, which is a complete unwillingness to perform. So that's also part of the Kumpatu case. All right, I know that's quick. I'm moving fairly fast, but any questions? All good? All right, we'll keep going. In the context of land contracts in particular, we have this concept of time of the essence. And one of the leading cases is Legione and Hartley. That's Legione against Hartley, Hartley. It's 1983 152 CLR 406. Have you noticed that most of these cases are High Court cases, and a lot of them around the 80s? So in Legione and Hartley, the argument was whether the sellers had lulled the buyers into thinking that the essentiality of time would not be insisted upon. It was a 3-2 decision in the High Court. And what happened was really interesting because a conveyancing clerk, in response to a request for an extension from the buyer, said, look, I think it'll be all right, but I'll have to get some further instructions. The seller said, no extensions. The conveyancing clerk went back to the other side and said, sorry, no extensions. You've got to settle on time, which they didn't. The sellers terminated the contract on the basis that the buyers had failed to settle and time was of the essence of the contract. And the buyers said, well, hang on, you lulled me into thinking that I'd get an extension. You said, I think it'll be all right, but I have to get some instructions. Now, the High Court said by 3-2, said that the seller, so the conveyancing clerk had not said quite enough to bind the seller, which I think is really quite remarkable. I would have thought with that phrase that clearly there's no express statement to say you have the extension, but it just goes to show how careful you need to be when making statements to your opponents, and just be very careful about being too friendly and too relaxed in that context. So that was Legione and Hartley, which sort of set off this discussion. Now another one is also within the context of real estate transactions is Tanwar, TANWAR, Enterprises against Cauchy, CAUCHI, Tanwar and Cauchy, 2003 217 CLR 315. Here's what happened in that case. The buyer was Tanwar, entered into a contract to purchase 3 properties from the seller, which is Cauchy. So Tanwar's the buyer, Cauchy the seller. was a problem on the day of settlement. Authorities in Singapore held up funds that were in transit. The money was there, but the Singapore authorities held up the money. Time was of the essence, and the purchaser was not able to attend settlement. The seller then terminated the contract. Time is of the essence. I put you on a requirement to settle on the day. You failed to do so. I'm terminating the contract. I'm declaring the contract at an end. I'm forfeiting the deposit. I'm keeping the deposit, and I'm reserving my rights to resell the property. If I sell at a less figure, I reserve my rights to sue you for the balance. Now, the buyer's money did come through the next day from Singapore. The buyer then said the next day, look, I'm now ready, I'm willing, and I'm able to effect settlement. I propose 3 p.m. Here it is. The seller said, too late, I'm not turning up. The matter went to the High Court. And the High Court said it was not unconscionable of the seller to terminate the contract in those circumstances. In other words, in Tanwa and Cauchy, the fact that the buyer had some problems that were not related to the seller and were not of the buyer's immediate doing was too bad. Now, the court helpfully did say that equitable relief may be available in certain circumstances. So essentially, by dicta, the court said if there's fraud or mistake or accident or surprise, then equitable relief may be available, but it wasn't available in these circumstances. So the questions that you need to consider are, if you've got a question like this in the exam, is did the seller contribute to the delay? Was the breach trivial? What damage did the seller suffer? And what was the magnitude of the buyer's loss and the seller's gain? Now, in that case of Tanwa, at paragraph 27, the court said, and this was talking about Legion and Hatley, that case made it plain that the principles identified as promissory or equitable estoppel may operate to preclude the enforcement of contractual rights and may stop a party from treating the contract as terminated for failure to meet an essential time stipulation. All right, all good for me to move on? It's an interesting area. I had the pleasure of taking conveyancing for one term when Dr. Nankara was unavailable, and I really enjoyed it. We talked about a lot of those cases, a lot of practical aspects. I take my hat off to conveyancers. I don't know how you do it. It's a really tough job and underrated too. People think conveyancing's easy. It's not easy. Anyway, at least in my experience. Okay, let's talk about some more equitable remedies, injunctions. So an injunction is an order to undertake to do something which is mandatory, or refrain, which is prohibitory, to do something. They're mostly to refrain. Injunctions can be interlocutory or they can be final. In environmental law, which I also take environmental law, and we deal with a lot of issues to do with that. So, for example, in environmental law, an injunction may be made by a court to restrain a person from undertaking activities that cause environmental harm. So that's a prohibitory injunction to stop them to refrain them from doing something. The injunction might also be mandatory, which is to force them to do something, requiring them to take some sort of positive action. Now, in environmental law, applicants will often ask the court for temporary or interim or interlocutory, if you like, injunctions, and that's to protect the status quo. So if you're talking about injunctions, just be aware that there are different types and they can come at different times of the litigation and they can be for different purposes. But generally, say in the context of environmental law, the purpose of the injunction application is to maintain the environmental situation until the court can make a final decision. But if you're asking the court to provide you with an interlocutory injunction, you need to establish a couple of things. You need to establish that you've got an arguable case, which we call a prima facie case, to grant the injunction. And you need to show that there's been a serious question that needs to be tried. This really matters. It's not just trivial. So you need to show that. And then you need to establish that the balance of convenience is in your favour. So the balance of convenience is a paramount consideration when it comes to dealing with the interests of the parties in an injunction case. All good? No questions? Okay. Restitution is another concept. So restitution may be a legal remedy, or it may be an equitable remedy. So restitution arises from the equitable concept of unjust enrichment. So if one party is unjustly enriched at the expense of the other, the court may make an order in restitution to correct that injustice. And the key example of a restitution-based order is quantum meruit. That falls within that concept of unjust enrichment. Right, well, as important as it is, I haven't talked much about the Australian consumer law, so we'll just talk about that now for a while. The ACL provides for a range of remedies, and I trust you've all looked at the ACL. I know Gary has, he's mentioned it tonight. So some of the remedies under the ACL: monetary penalties, injunctions, damages, compensation orders, and even pecuniary orders. So pecuniary orders can be made if a person has contravened or attempted to contravene certain provisions of the ACL or has been a party to that. So lawyers need to be always careful that they're not drawn in as a party to a contravention. So in determining whether to make a pecuniary penalty order, the court will consider the nature of the community service, the nature and extent of the act or the omission, any loss or damage that may have been suffered, the surrounding circumstances, and if the party has engaged in similar conduct. So that's available, but it's not the primary thing that we're talking about tonight. Injunctions we've talked about, available, as I mentioned, under the ACL. But probably the most important of the remedies available under the ACL is damages. And if a person suffers loss or damage by the conduct of another in contravention of, say, chapters 2 or 3 of the Australian consumer law, then that party can recover damages. And that's have a look at section 236, as Gary pointed out earlier, of the ACL. Now, there are time limits, and an action for damages must be commenced within 6 years after the date on which the cause of action accrued. Now, the court, in implementing the ACL, does have a wide range of discretionary relief available to it. And that can be in favour of a person who has suffered or is likely to suffer any loss or damage by conduct comprising a contravention of chapters 2 or 3 or 4 of the ACL. Those of you that work with me in statutory interpretation will know that I'm very keen for you to adopt a practice. When you look at a statute, always look at it globally first before you start to read any specific sections, to get a feel for the layout and the structure. So have a look at the headings and the chapters, get an idea of how it all fits together. Then have a look at the objects clause and any relevant definitions, and then go in and have a look at the section. So before you look at 236 and 237 in detail, do get a feel for what we mean by what's in Chapter 2, what's in Chapter 3, what's in Chapter 4 of the ACL. All right, so as I mentioned, the court has a wide discretionary power to grant orders if someone has been wronged. Now, one is a declaration. The declaration might be that the contract is wholly or partly void. There might be an order varying the contract. There might be an order for the refund of money or the return of property. There might be an order for compensation, or there might be an order for things like repairs or the provision of parts or services. So if you've got a contract law-based question and you're thinking about an appropriate remedy, you must consider those options that are available under the ACL, because odds are that's where you'll be going. Statistically, I think it's fair to say that most of the actions now are under the ACL, not strictly under common law, not strictly under equity, but mostly the ACL. So look at those range of remedies that are available to a court, then try to structure your arguments and your approach towards that. Now, an important thing always is damages and causation. Your client may suffer substantial damages, but remember, of course, you need to establish the causation between that loss and the opponent's actions. So an applicant must establish loss or damage because of the respondent's conduct, and that's ACL section 236 1A. You've got to establish a causation between the damage and the contravention. For example, by relying on the misleading conduct of the other side. Now, there is the option for severance as well. So have a look at ACL section 23 in that regard. A term is void in a standard form of consumer contract if it's unfair. Now, it's not necessarily the entire contract. It may be that the court can sever, can remove that part of the contract that is unfair and therefore void. So it may be that the contract continues and binds the parties if it can operate without that unfair term. Have a look at ACL section 23(2). So we say that the unfair term is severable and is severed from the rest of the contract. An example of that is Director of Consumer Affairs against AAPT, Pty Ltd, or Limited rather. It's a VCAT decision. It's 2006 VCAT, which is the Victorian Civil and Administrative Tribunal, 1493. Now, AAPT included as part of its standard consumer contract a range of clauses which were found to be unfair, and some of them were the ability for AAPT to change the contract unilaterally, charge reconnection fees even if it wasn't the customer's fault, immediately terminate the contract for a range of circumstances, for example, not advising AAPT of a change of address. Yes, and that's it, Gary got it. One of the clauses was if someone changed their address, they could terminate, exactly. And change in the terms of prepaid mobile customers. So the court held, or the tribunal in that case held, that the contract could continue to operate with the clauses removed. And the question is, can that happen? Can it still operate with those clauses out? The tribunal said yes, it can, and therefore the provisions of the contract were all severable. So to summarise, in relation to unfair terms in a consumer contract, the court may make a declaration that it's unfair. Have a look at ACL section 250. If the party relies on a term declared to be unfair under section 250 and the other party suffers loss, then there's always damages available under section 237. If the contract can continue to operate with the term severed, then it will do so. But if the contract cannot continue to operate, then the entire contract will be terminated. Also think about representative actions as a possibility. So for consumer affairs issues, have a look at sections 237 and 239. So for example, in the AAPT case, there was an entire class of customers likely to be affected by the breach of the ACL. So it was, if you like, a representative or group or class action. Another remedy that's available under the ACL is undertakings. We see this sort of thing a lot in environmental law as well. It's where the ACL allows regulators to work with rather than necessarily against a supplier or a manufacturer who has breached the ACL. So if you're thinking of potential remedies, coming back to my introductory comments at the start, don't always immediately think it must result in commercial litigation. There may be other ways to deal with this. So the ACL actually allows for that. Look at section 218 of the ACL. A regulator may accept a written undertaking. Then if the undertaking is not complied with, the regulator can act. But if the court finds that there has been a breach, the court of the undertaking, the court can take a number of actions against the party that gave the undertaking. Paying profits, for example, might be one of them, compensation, or actually complying with the undertaking, which is effectively specific performance. Another thing that is available under the ACL is injunctions. So have a look at section 232 of the ACL. It provides extraordinarily based broad injunctions, and there are some key features. Now, we know what an injunction means. It can be effectively to stop or to force. So an injunction can be applied for by the regulator or by any other person. So just latch onto that extra phrase in section 232 of the ACL, because, and Amy says, should we bring a copy of the ACL into the exam? Yeah, I would say so. And Samara said, yeah, I bring everything in. Yeah, I agree with that. And if you watch my video, I'll recommend that you have half of the answer written even before you walk in. Let's see if you can guess what the question is. So an injunction can be applied for by the regulator or by any other person. Now, a person does not have to be affected by the behaviour complained of. They don't need to establish loss or damage. They don't even have to be a party affected under the ACL. In other words, the rules in relation to standing aren't strictly enforced if you're looking at section 232 of the ACL. Now, the second thing is an injunction can be taken out not only against a person or company which has engaged in or is proposing to engage in a contravention. It can also apply to anyone in any way directly or indirectly knowingly concerned in or a party to such a contravention. So what do we take from that? Watch out lawyers, watch out accountants. You may be drawn into the litigation on the basis that you are directly or indirectly knowingly concerned in the contravention. Now, the third thing is an injunction may be granted on terms that the court considers appropriate. So it can be very broad. And have a look at section 232 subsection 6, which provides some things that the court consider. I mentioned some earlier, refund of money, for example, or it may be ordering a transfer of property, or ordering a party to honour a promise or an undertaking, or it may even be an order to destroy or dispose of goods. So it's really broad. So the takeaway from this evening is that when you're considering remedies beyond mere damages, you need to consider equity, common law, statutory provisions, particularly the ACL. You need to have an idea of how they fit in the pecking order, have an idea of how you would approach answering a question and what would be your lead argument, and would you then also introduce alternate arguments, which you probably would consider. How would you frame the order? Would you only consider commercial litigation, or would you consider alternatives? And if you considered alternatives, would you introduce something about your ethical obligations to do so as part of your answer? So there's a whole lot of things that you can do. And when it comes to remedies, you can be really quite creative in your approach. Now, Samara, I missed one of your questions. Was there something you wanted to raise or ask? Not putting you on the spot, but. And indeed, anyone, does anyone have any questions, comments? Otherwise, that'll be just about it for tonight. All good? Well, thank you all for joining me on Australia Day holiday. I try not to have live sessions on holidays, but I've missed out on a couple of live sessions, so thank you. All right, well, thank you very much, and we'll hopefully get some results back to you fairly soon. I have to wait for people to submit their work, but once that's happened, I'll get those results back and we can start preparing for the final examination in earnest. All the best, and we'll see you next week. Bye then.